Hello everyone, welcome to the Business Law 210. Our new subject currently is about duress, undue influence, and illegality. What will be the lesson objective of today's subjects? By the time you learn this subject, you will be able to define duress. You can match case names to the facts. Most learners will be able, we are expecting that you will be able to list cases and apply the case law in regards to duress as a defense. Some might be able to list cases and apply it in regards to duress as a defense, and it might be applied duress to problems question. What is duress? Duress is when does this seems means to you? What does this term mean to you? Yeah? In what situation do you think duress can arise? The issue of duress arises whether defendant is threatened and he must commit a criminal offense or suffer physical injury or injury to his family, and this type of duress is often referred to duress by threat. What is responsibility and liability in this case? The liability. The legal obligation set forth in a contract or statute bestowed to a person or legal entity related to the performance he or it has to fulfill. What is the exemption? The exemption is there's no injury is done to a person who consent or voluntarily non-fit injuria. What is your responsibility? What is the party's responsibility in this case? A person accountability for an outcome to which their action have contributed. Together with any legal obligation, they might have to repair any damage caused. The difference here is the liability is assigned or stipulated while responsibility is assumed. Duress can be an actual or threatened violence to or to deprivation or removal of liberty of a person's family or relatives to pressure or coerce such person into entering into a contract. Another definition of duress is any unlawful threat or coercion or force, intimidation used to induce another to act or not act in a manner they otherwise will not or would not do. Duress also defined as a threat of harm made to compel, force, or induce a person to do something against his or her will or judgment, especially a wrongful threat made by one person to compel a manifestation of seeming assent by another person to a transaction without real volition or wish, will, or preference. Duress can be as a legal defense. Duress or coercion is a possible legal defense by which defendants argue that they should not be held liable because the action that broke the law were only performed out an immediate fear of injury. A person might raise a duress defense when force or violence is used to compel him to enter into a contract or to discharge one. However, it cannot be used as a defense for murder cases. Duress is when a contract made under duress is voidable at the option of the party coerced. He or she might elect not to be bound by the contract. Further about duress, you might click the link that I share with you on YouTube on page 9. This is how duress is applicable in the contract law. What is the requirement? In order for duress to qualify as a defense, 4 requirements must be met. First is threat must be of serious bodily harms or death. The second thing is harm threatened must be greater than the harm caused by the crime. The third one is threat must be immediate and inescapable. And the last one is the defendant must have become involved in the situation through no fault of his or her own. A person might also raise a duress defense when force or violence is used to compel him to enter into a contract or to discharge one. The defense cannot be used for cases of murder. Duress in the context of contract law is a common law defense, and if one is successful in proving that the contract is vitiated or makes something faulty, makes something ineffective by duress, the contract might be rescinded since it is then voidable. So the contract made under duress is voidable at the option of the party coerced, or he or she might elect not to be bound by the contract. The duress contract law falls into two broad categories. When there's a physical duress to the person, and then this is actually duress to the person. And duress to goods is also applicable. And duress to the goods, in such case, one party refused to release the goods belonging to the other party until the other party entered into a contract with them. The contract was set aside after the case of Fajar Pacific Limited versus Helicopter Chapter is when the Fajar Pacific threatened to withhold the helicopter from the plaintiff unless further payment were made for repairing a damaged paint job. This is described on page 16. Next, we move into undue influence. The undue influence is the improper use of the ascendancy, dominance, power, superiority acquired by one person over another for the benefit of the ascendant person, so that the acts of the person influenced are not his or her free voluntary acts. It involves a disparity or inequality of bargaining position, where one party is dominant and the other is weaker position. It usually arises in transfer of property for no consideration or inadequate consideration. What is the special relationship in undue influence? Where the following special relationship exists, undue influence is presumed in dealings. In such cases, the onus of proof or responsibility of proving that it was not exercised on the party denying it the stronger party. This is an example. The onus lies on a doctor, where they disapprove undue influence on a patient. There's a special relationship in undue influence. When such relationships exist, called certain relationships, it raises the presumption that undue influence has been exercised. The complainant will also need to show that he or she has put his or her trust and confidence in the wrongdoer. By doing so, she raises the presumption of undue influence. Thus, in these cases, the complainant will succeed in setting aside the transaction merely by proof that the complainant put his or her trust and confidence in the wrongdoer. Some institutions where undue influence might exist, for example, parents and child, doctor and patient, religious advisor and devout priest member of parish, solicitors and client, guardian and dependent. These are an example what does fiduciary means. The act of good faith, put client interest first, disclose all conflicts of interest, never mislead client, and provide full disclosure. When you have a cases of Sullivan versus a management agency and music, here the manager was held to be on page 25. Here the manager was held to be an fiduciary relationship with the claimant, and accordingly the agreement were presumed to have been obtained by undue influence. In the case, fiduciary definition means there's a legal duty of loyalty and faithfulness toward another's. In the case of Lloyds Banks versus Bundy, an elderly farmer who has on page 27, this is the case where an elderly farmer who was not versed or skilled in business affairs was persuaded by his son to guarantee the company overdraft for an amount of $1,500 and to charge his house to the bank to secure that amount. The company ran into financial difficulties, and the assistant bank manager suggested that the father should sign a further guarantee for $5,000 at the time the house worth for $10,000. What's happened then? A new assistant bank manager together with the son persuaded the father to increase the guarantee and charge to $11,000. And the assistant manager was aware that the father relied on him to advise him about the transaction as a bank manager. The Court of Appeal held that the relations between the bank and the father was of trust and confidence, and accordingly the father, in coming to a decision about the proposed transaction, was liable to be influenced by the bank's proposal. Here, in these circumstances, the confidential relationship imposed on the bank a duty of fiduciary care, that is, a duty to ensure that the father formed an independent and informed judgment before committing himself. Since the bank had failed to advise to the father to obtain independent advice, it was in breach of its fiduciary duty to the father, and therefore the guarantee and charge was set aside. If undue influence is proved in a contract, the contract is voidable by the innocent party, and the remedy is rescission. A person who has been induced to enter into a transaction by undue influence of another or wrongdoer is entitled to set that transaction aside as against the wrongdoer. Next is about the illegality. As illegality is an illegal agreement under the common law of contract, is one that the court will not enforce because the purpose of the agreement is to achieve an illegal end. The illegal end must result from the performance of the contract itself. So a contract is void if it is based on illegal purpose or contrary to public policy. Some illegal contract under the common law you can see on page 33 on your PPT module that I share with you. There whereas a contract, one of the example is designed to defraud the government of revenue. Or you can contract to commit an unlawful act, to commit a crime or fraud. Effect of legality is one type of unenforceable employment contract, include contract agreeing to work for less than minimum wage and forfeiting the right to workman's compensation in cases where workman's compensation is due. Illegal contracts are void at common law provided the illegality was present at the time of the contract was formed. Money paid cannot generally be recovered. Thank you very much for having me and looking forward to see you in the next session. Have a good day.